Many carriers trying to be innovative or distinguish themselves in the legal malpractice marketplace try to add certain coverages to the policy, hoping to get your business. While any additional coverage is a good thing, sometimes the advertising and marketing of the additional coverages can cause confusion about the type and the extent of the additional coverages offered. Some of the additional or ancillary coverages that carriers in the LPL marketplace are marketing are cyber coverage, directors and officers coverage, fidelity coverage, and even some business owners coverages. Again, the additional coverages are not bad to have, but they should not be thought of as complete coverage for that type of exposure. All of these ancillary coverages are just that. They are ancillary. Don't be fooled in thinking that the ancillary coverage is all you need for those exposures. The ancillary coverage will provide minimal coverage in terms of depth and limits. For a more comprehensive coverage with broad depth and adequate limits, you really should consider a standalone or separate policy for each of the exposures that exist in your firm. Although buying separate policies for cyber, business owners, and crime coverage will add to your outlay of cash, it should also provide adequate protection for you and the firm in the event of a claim or loss. Notice I didn't mention D&O coverage in that statement. If you sit on a for-profit or non-profit board, you definitely need to check with that entity and confirm that they do have an enforced policy that protects you in your position as board member. Don't depend on your LPL policy to act as a cover-all policy. It's not. It's great to have supplemental and ancillary coverages in the legal malpractice policy, but it's a mistake to believe these types of coverages will provide the coverage you need in a claim situation. Investigate standalone policies. Thanks for listening, and remember, I'm Don I, your insurance guy.